welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is William Mahan, and I'm just going to call him Bill. And Bill is an attorney, has a law office in San Jose, California. He is of counsel to Gates Eisenhart Dawson. He's been practicing law for about 33 years, has a master's in taxation, LLM from Golden Gate University, and he has a JD or law degree from Santa Clara University. His practice focuses on estate planning, probate, and business planning. Today, Bill and I are going to be talking about tax and financial considerations of title. And as we get started in this, I'll caution our viewers to seek legal advice, and that we're talking about California law. Bill is a California attorney. I'm a California CPA. And there's even peculiarities from state to state related to how community property works and things like that. So anyway, we're just trying to introduce a topic here that will hopefully be a conversation start with your own attorney or tax advisor. Okay, Bill, let's get started. What are some alternative forms for holding title to property?
If you're a single person, you can own property as your separate property.
Mm-hmm.
People own property jointly as tenants in common or joint tenants. That usually includes something called right of survivorship.
Mm-hmm.
If you're a married person, you could own property with your spouse as community property.
Mm-hmm.
That doesn't apply to unmarried people.
Mm-hmm.
There's also something not new but newer called community property with right of survivorship, which is sort of a combination of community property and joint tenancy.
Mm-hmm.
And then people own property or title property in the names of entities or trust accounts as a way of having a beneficiary usually for the account. So you can have a custodial account for minors. You can have what are called Totten trust account or payable on death accounts.
Mm-hmm.
And then you could set up your own trust and transfer property to yourself as trustee of your trust or some other person as trustee. And then people also own property inside of entities like partnerships, corporations, limited liability companies. So they own the entity instead of the asset itself, but
Mm-hmm.
by putting the asset into the company, they hold title to their property in the name of the entity.
Okay. Now, maybe a little bit of differentiation. So tenants in common, that's like undivided interest, right? So
Yeah.
you can, in a sense, you could have a separate property interest or a community property
Right.
interest inside of this.
Yeah, sometimes the titling is a combination of things. You'll
Yeah.
even see people who own property, like you'll own property and a husband and wife within the title will have it as joint tenants with right of survivorship and other people don't. Tenants in common is these distinctions actually mean quite a lot.
Mm-hmm.
They're not but people hear these words and they don't realize that the titling actually means something quite significant.
Right.
So tenants in common is actually a way for people to own property jointly, but they all own the whole property.
Mm-hmm.
So if it's an undivided interest in the property, they have an equal right to use the property, to benefit from the property. So it's not like a partnership where they own 20% of a partnership as opposed to somebody's 80%. You can hold property in different percentages, but tenants in common have this kind of unity of ownership of the property.
Mm-hmm. Okay. Now, today is September 3rd, 2013. We had a recent Supreme Court Windsor decision striking down the Defense of Marriage Act relating to community property for same-sex couples. So, would you care to comment at all about the significance of that decision, maybe related to this subject that we're talking about of
Right.
title?
Well, same-sex couples are now allowed to legally marry in some states, not all
Yes.
states, but California is
One
one.
of them.
And what that means is that same-sex couples can have community property in California. They could before, because even as registered domestic partners, they could have community property in California. But none of that was recognized under federal law. So all of the rights of spouses under state law in California didn't apply under federal law for the same couple. So when the Defense of Marriage Act was found to be unconstitutional, What that means is that now the federal government is recognizing a legal marriage as a legal marriage. And therefore, the federal laws that apply to spouses apply to same-sex couples who are married. And so things like the estate tax laws, the laws for stepping up basis for community property, those all apply now for same-sex married couples same as they would for married couples prior to the change in the law.
Okay. So we've sort of got into this thing a little bit. Maybe I had it originally on the outline a little farther down the road, but why don't we talk a little bit about community property and how it's a little different from other types of property related to basis rule, particularly for jointly owned properties.
Right. Well, as I said before, community property applies for married people. So anybody who's legally married can own community property. They don't have to. They can still own the separate property inside of a marriage. They need to specify it that way. But if it's community property, it is unique in several ways. And one of the ways in terms of what happens when people die is usually the community property goes to the surviving spouse. You can leave your share of community property to someone else, but usually it goes to the surviving spouse. And because it's community property, there's something in the tax law that says when a person dies, you get to increase the tax basis of the property to the fair market value at the date of death. If you own property as joint tenants, then it's only the decedent's interest in the property that gets an increased basis at death. Whereas if it's community property, the entire property gets an increased basis, fair market value at the date of death. So that's, I think, the primary reason why community property with right of survivorship was brought into our law, was because the joint tenants with right of survivorship was creating this basis issue. Community property allows you to have right of survivorship and the full stepped up basis on the date of death value. So that's, community property is sort of unique in that aspect because you can increase the basis for both spouses' interest in the property at the date of either spouse.
Right. So this is a significant tax benefit for community property, if in fact the value of the property goes up.
Yeah. It used to be, it always went up, right? And then it didn't, and now it's going back up again. So
yeah, and again, so in the tax law before, basically what the Internal Revenue Code, I think they would recognize community property in general, but they didn't allow this double step up.
Well, before, even if the property was titled husband and wife as joint tenants, it was still possible not to proceed under joint tenancy when the person died. In other words, there's something called an affidavit death of joint tenant that would get recorded and change the ownership to the survivor. Well, if the people were married, then the correct thing for the person handling that estate would be not to do that. Because if it was community property, then you just went ahead and treated it as community property and didn't use that procedure to clear the name of the deceased spouse from the title, and then you just still got the stepped-up basis.
Actually, what I was getting around to was the thing about the same-sex couples. So for the same-sex couples, there was actually language in the Internal Revenue Code previously that said that they wouldn't get this double step-up. And you could only get it if it was a two-sex couple. So anyway, but that question I think has been pretty well resolved now with this Windsor decision.
No, I agree.
And by the way, the IRS has recently come out with a revenue ruling that's been very liberal in how they handle this same-sex couple status when they're married. And basically they say, once you're married, that's it. You are married. It doesn't matter where you live.
Right.
We don't care. From now on, you are married until you get formally divorced.
Right.
So
The important thing there that they said was, if you're married in California and it's legal, if you move some other place another state where they don't recognize same-sex marriage, you're still, for federal purposes, married.
Yeah.
That's very important for people.
Right. And the rationale that they said that they were following was an old law for common law marriages, and it was ruling made back in 1958, and they said, we've been doing this for over 50 years, and so we're just going to give the same treatment for this situation. And administratively, I think it makes a lot of sense.
Right, I agree.
Yeah. All right. Well, Let's talk a little bit more about some title things. How do people try to bypass probate using title?
Well, the primary thing they do is something like joint tenancy with right of survivorship. Because the right of survivorship means that the surviving joint tenants own the property, if a person dies, doesn't have to go through probate to have that happen. It doesn't have to be real property. It can be a bank account or anything like that. So joint tenancy, again, using trust accounts and things like that with beneficiaries, that's another way of getting property to transfer at death without having to go through probate. It doesn't necessarily work very well. Well, unfortunately, it works enough for people to believe that it works well, but it doesn't always work well, because if the people don't die in the right order, then you have a significant problem.
Oh, yeah, okay. And I guess another way that you could do it is using one of these Totten trusts, so you can sort of direct, this bank account is going to be payable on death to a beneficiary.
Right. Anything with a beneficiary designation in it can be used as a way of avoiding probate, whether it's annuities or life insurance or trust accounts or whatever.
Yeah, retirement accounts. Okay. So what do you think the biggest mistake people tend to make related to title?
Well, I'd say in my years of experience, probably the biggest mistake consistently is people trying to do it themselves. Because conveyancing is actually very complicated. If you don't do it correctly, you can create a really big problem. And I've seen deeds and things like that have titling that's all mixed up, different words and language that means different things. It all sounds very legal because they're words that you see in deeds, but when you put them together in the wrong order, they really don't accomplish what you want, and sometimes it's almost impossible to know what you actually meant. So I think that's the biggest mistake, really, is not doing it correctly. If you do it correctly, it does what you want. If you do it incorrectly, it just creates a cloud on the title to your property.
Okay. What are some concerns about holding property as joint tenants with children?
Again, this is something that's common, either children or even other people. The idea being that it's a simple way to change title if somebody dies. It avoids probate. But people don't think about the fact that if something happens before they die, it can create really significant problems, such as I said earlier, people don't always die in the right order. So parents put their children on title as joint tenants with right of survivorship, and then the parents are the ones surviving at the end of the day. That didn't get the property transferred to anybody else, and so now you have a probate, and you're going to deal with it as any other probate estate, because we don't know where the property is supposed to go anymore. So just people not dying in the order you think they're going to is a problem with it. The other kinds of problems are that when you put people on title to your property, if there's a big problem in their life, like a bankruptcy or a divorce, a large judgment, now your property is part of their name is on your property, and now you have to clear that up. And I've seen situations where people even have, other people trying to take their property because of a judgment they have against somebody else who's on title. So having people on the title with you can be actually very dangerous. Another thing that happens is sometimes the people just have a dispute amongst themselves. And I've seen court cases where parents and children were fighting because the parents added the children to the title, and then they had a falling out, and then the children refused to get off of title, and the question was, did they make a gift when they added them? So it becomes very messy. So there are just better ways to do it. There are better ways to pass property without adding people to the title of your assets.
Yeah. Another thing is, I think, like if you do it with real estate, you've made a gift.
It's possible that you've made a gift. That's always one of the questions is, have you or haven't you made a gift?
Yeah.
And if you have, then you can't really get them to, like I said, trying to get them off a title if you don't want them to be there anymore. If you've made a gift, they don't have to go off the title.
And even if you have a bank account, if they take the money out of the account, then definitely you made a gift at that point. So
well, you may feel differently, but
maybe you didn't think that you did.
They legally took it out.
Yeah. All right. How can a husband or wife, spouse these days, I guess, accidentally transmute separate property to community property, and what are the consequences?
Well, under the law, married people have the right at any point in time to determine between the two of them the status of their property. That's the law. So if you're going to do that, you should do it in writing, because otherwise it's really just an argument, that what did you do it or did you not. But if you come into a marriage with assets, that property is your separate property. The fact that you got married doesn't automatically make it community property. If you wanted to keep it separate, well, you could have a premarital agreement. That's one way of establishing the fact that it's separate. But even if you don't do that, if you conduct yourself in such a way as to keep it a separate account or something like that, don't commingle other assets with it, then it stays separate property. But once you're married, things such as your earnings become community property. And so if you start commingling earned income with other money that you had before you were married, you've created community property just by putting your paycheck into a bank account, for example. So it's fairly easy to taint and change the status of some property accidentally or unintentionally. Assets like real estate, it's a little harder. It takes a little longer. It doesn't happen all at once. But if you have a piece of real estate that's separate property, and you start paying the mortgage and fixing the roof and doing other repairs and paying the property taxes out of your paycheck, you're again creating a community interest in that property because you're using community funds to pay for it.
And suddenly you've got a tracing issue of
right.
maybe, particularly if you get into a divorce situation.
It gets very complex in divorce. Yeah. It also does, though, come up in death, death, because if you think about it, if you're going to leave your separate estate to your children and your community estate to your spouse, because you have children from a prior marriage, for example, you have to figure out what those estates are. What is the separate estate and what's the community estate? So you have the same kind of tracing issues.
Yeah. Yuck. Okay. So is there, well, maybe we'll just talk a little bit. There's been a tendency historically, I think, for the default, if you will, like when you buy a home, the title company or whatever, whoever's processing, they would sort of automatically do this, the title as joint tenancy. Maybe you could comment about that for a few minutes.
Yeah, for married people, that was for years the preference by title companies was to set it up as joint tenancy, and I think that was because they felt that created a little less liability to them if something wrong happened between the couple later. Whether that's true or not, I'm not sure, but that sort of seems to be what their feeling was. And so their bias was toward doing that. I don't think that's as true now as it was, because now we have things like community property with right of survivorship. And I think they've just become a little more sophisticated. It's even much more possible now, if you have a living trust, to get a title company to let you title some newly acquired property in the name of your trust from the beginning, as opposed to doing multiple deeds to get it into the trust.
Could save a couple of bucks. Okay. Well, you've already talked a little bit about community property with right of survivorship, so I think I'm going to move on. What are some title considerations for entities like trusts and family partnerships?
Well, probably the biggest difficulty in that area is just actually doing the titling work. I don't know why, but a lot of times people will set up a family partnership or limited liability company, or even with non-family members, and the property, you'll see it years later, and it'll still be in the names of the individuals. Or the same with the trust. You don't get the property funded into the trust, so it's still in the individual names instead of the trust name. And so that can create really significant legal problems and estate problems and just all kinds of problems, because the question again is who actually owns this property. And if you're setting up an entity to get limited liability protection, but you maintain the property in the name of the individual owners, then you probably haven't accomplished that either. So actually following through with this stuff and doing it correctly and getting the title into the name of the trust or the entity is very important.
Yeah. So this is a real issue, though. Well, they're like what we call boiler room trust mills or whatever. So a lot of times people aren't paying attention to the details.
Yeah, the individual clients probably don't know the details. I mean, they're not really aware of what needs to be done or what the importance is. So you're relying on the people who are helping you in the process to do it all right. The other thing that happens is sometimes people will set up a trust or something such as that, and then put their property in the trust, and then they'll want to refinance, and so they'll go to a lender, and the lender will say, well, we'll give you the money, but we want you to take it out of the name of the trust. And so they take it out, and then it's
Then they forget to put it back.
back in the name of the individuals, and then
Yeah.
it doesn't get back in again.
Yeah, and it can create some complications too of where you have different titles, again, ownership of property. And I've seen this before, maybe a parent owns the property with their kids, and they say, oh, well, we need it to be in such and such's name. And so now they want to do it there, and then they forget to put it back, and again, you've created this
Right.
issue. And there are maybe other family members involved. Next thing you know, you've got this big conflict.
Right.
Uh,
And the other place this comes up, and I've seen it quite a lot, is in order to help children buy property, parents will go on title,
oh, yeah.
or other people, because the lenders want that. But they didn't really intend to jointly own the property 50-50 or something like that.
Yeah.
So, but the title indicates they do. And then you have a problem of unraveling that situation. And
Yeah.
how do you do that without some kind of a gift or some kind of transfer?
Yeah. So anyway, there's just an unbelievable amount of hassles that can happen, and unfortunately they relate to everyday occurrences in life, and
Right.
so we have to sort of fix these later, and unfortunately it can create a lot of expense and inconvenience. Maybe you can comment for a few minutes about California property tax considerations when you change a title.
Well, in California, we many years ago had something called Proposition 13, which was a way of avoiding having people's property taxes go up unless they actually sold their property. So the idea was, unless there was an actual change of ownership, which are the key terms, the property shouldn't be reassessed. So now we have a situation where people transfer property, and every time they transfer the property, the assessors want to know, is this a change of ownership? Because that means we can increase the assessment. And if it is, then they can. If it isn't, they can't. And there are exemptions to the change of ownership rules. So transfers with spouses, transfers from parent to children, transfers from individuals to a living trust, transfers from individuals to an entity that they own in the same proportion as they owned the property before it was transferred. Those are all things that are excluded from reassessment. In order to prove that, you have to show the assessor's office at the time of the transfer that in fact it's exempt. So there are forms that need to be filed. There's something called a PCOR that needs to be filled out each time something's recorded and filed, explaining to the assessor's office whether or not it's a change of ownership. There also are transfer tax issues that have to do with just recording documents and whether the county can charge you a transfer tax, and there are exemptions from that as well. So those are all areas where you have to be careful of how you do things. If you do things in the right order, you can avoid or minimize those kinds of taxes and changes in assessments.
All right. So, again, this is one of the details that unfortunately can sort of fall through the cracks, particularly like when families try to self-administer
Right.
their estates. That there is this form that needs to be filed, and without it, basically the county will try to do a reassessment, and I believe that they can penalize you in some cases if you don't file the form. And so it's just important to get this paperwork done whenever there's a change of ownership.
Right. Or anything recorded. Anything that's recorded needs to be explained these days, and that's the system.
Well, there may not even be anything recorded. So you may, again, you have a trust, and if you have a change that happens because, again, if somebody passes away, and now, in essence, it's gone to the beneficiaries of this trust, even though the title may still be held in the trust for some time, there may actually be a change of ownership, and again, there can be retroactive assessments, penalties,
Right.
and so
Well, see, until something gets recorded, they're not really aware of it,
Yeah,
and then they
yeah.
look at it and
Yeah.
then they see that, oh, this happened.
yeah, this happened 5 years ago or whatever.
Right.
Okay, Bill, well, we just have a couple of minutes left. Maybe you could make some final comments related to this area of tax and financial considerations of title.
Well, let me say just in general that it's harder these days to get things recorded. Recorders are more careful and a little more reluctant to record just whatever they receive. But for the most part, if a document is drafted correctly and notarized and is something that's recordable, then the law requires them to record it. So the point I'm getting at is that people just write up things, sometimes just in freehand, and record them, and they become part of the official record. And so it's not that hard to record things that may be completely erroneous or not what you actually wanted to do. So, as I said in the beginning, conveyancing is complicated. If you are going to have something transferred and recorded, it's important to do it correctly. And then for other assets like your accounts and things like that, again, you need to be careful what you're doing with those things, and keep in mind, for example, that if you have a life insurance policy that has a beneficiary designation and you have a trust and something else, the life insurance is going to go to the beneficiary that you named and not go through your other planning documents. So you have to be careful with all of these things that you're setting up and make sure that they're going to do what you want, and get advice from people like financial advisors and attorneys and possibly CPAs to get the tax consequences of what you're doing.
Right. So, again, it's important to pay attention to details. When you try to do these things yourself, you may not know how this whole picture is fitting together. It also means, though, that you have to give the information. Hopefully the attorney is going to do a good job as far as gathering the information. What are the life insurance policies that you have and so on, so that they can do that. Bill, thanks for joining me.
My pleasure.
It's been a pleasure having you here today. Folks, I hope we've given you some things to think about. Like I said, this is a conversation you should be having with your own attorney to work through the details for your own situation. We'll see you next time on Financial Insider Weekly.